Oh, here we go. Good evening. Thank you for coming. For those who don't know me, I'm Dottie Powers, but I think everybody here knows me, your town clerk. And this is a great way to bring all of our board and committee members together to acknowledge their service to the town of Westwood. I am the official oath giver of the town. An oath is defined as a solemn allegiance, a promise of obedience and faithful performance of duties which should not be taken lightly. Administering and recording the oath is one of the most important duties of the town clerk. What does it mean for you to take an oath of office? It means that you will promise to apply all the education and skills that you have accumulated over the years to the service of the town, and that you will vow to members of the community to honestly and impartially serve them. I will be administering the oath of office to all reappointed and newly appointed board and committee members at this time. So could I please have everybody stand and raise your right hand, and please repeat after me. I will faithfully and impartially perform the duties of the office to which I have been appointed in accordance with the bylaws of the Town of Westwood and the laws of the Commonwealth. Thank you, and thank you all for your service to the town. And now I'm going to introduce Mike Gillette, who would like to say a few words, our town administrator.
Okay, thanks for coming. I'm going to make a brief presentation, just summarizing the appointed committee handbook which was prepared. This is a newly prepared document that Christine and I believe Dottie worked on feverishly over the last several months, and that the Board of Selectmen recently adopted. So I'm just going to say a few words about that before turning the microphone over. I will note that it's titled Appointed Committee Handbook, but it also applies for elected committees as well, or boards and commissions. Why is it important to pay attention to the conflict of interest that we're going to be discussing here tonight with Lauren and Brian on open meeting law and ethics? The purpose is to ensure that you are serving transparently only the town's best interest, not your own, not your families, not your business partners, but the town's best interest. Supposed to be looking this over. Why do you have to be sworn in to your role on the board? As Dottie just pointed out, it is important for you to swear to serve the town's interest, and we take that seriously. I'm told that if you're a judicial, quasi-judicial committee, such as a Board of Appeals or a Conservation Commission, the oath of office is especially important because litigation could result in a loss if people aren't sworn in. Question is always asked, can I speak on behalf of my board or commission? The answer to that is only if you have been authorized by a majority vote at your board or commission can you say that you're representing something about your board or commission. If you are speaking as an individual, as a citizen, you should say that you are speaking as a citizen and not as a member or on behalf of your board or commission. Usually the people that speak on behalf of their board or commission is the chairman and the staff person assigned to that board or commission. Do I need to respond to the inquiry of whether or not I want to be reappointed? At this time of year, Christine in my office sends out a request of all people whose terms are terminating and asks, do you want to be reappointed? It's important to respond to that you are or you aren't, so we can make sure that we can fill the positions so we can do business after July 1st, and the board can make the appropriate appointments on a timely basis. In the course of the year, if you decide, whether it's the first, second, third year of your term, to step aside before the end of your term, it's important that you submit a written notification or letter to the appointing authority. Most of the time that's the Board of Selectmen, and to the Town Clerk. It should be addressed to the Town Clerk with a copy to the appointing authority. What is the difference between ex officio members and associate membership on a committee? Ex officio membership on our committees are basically the staff that have been assigned to work with the committees. We make it a practice to always assign staff to work with committees to assist them in conducting the business, accumulating the information, doing the research, and the legwork between meetings and during meetings. We also expect them to attend the meetings, to offer information, help clarify issues, and answer questions. Associate membership, and we have recently, when we did the charter revision, made a provision for associate membership. Associate members are those that are appointed to be able to be called upon in the case of a member not being able to be participate in the process, or a public hearing, or a decision-making process. And a couple of reasons would be that the member has a conflict of interest with the issue in front of them, or a member is taken ill or been injured and not able to make it, or simply out of town or on vacation or something of that nature. And so the associate member would be appointed by the chairman of the board to serve on that public hearing process and assist the member in the decision. Why do we need a chairman? Well, the chairman has an important role to play on all boards and commissions. I'm one behind all the time. Okay, the chairman usually sets the agenda, ensures that the membership has appropriate information, that the meeting are posted, and especially that the conduct of the meeting is appropriate. Chairman should always set the rules at the beginning of the meeting, that all discussion should go through them. Do not, if you're a chairman, you want to make sure that the discussion doesn't go back and forth between individuals without going through you as a chairman. The member also ensures that the open meeting law are abided by, and that the appropriate decisions are made as to whether or not to go into executive session. It would be the chairman and or the staff that would check with town council before the meeting starts with an issue you think should go into an executive session, and follow town council's advice. The other point I'd make is that the chairmanship should always rotate. It's good to have a turnover. The Board of Selectmen, for instance, formally turns over the chairmanship every year on a rotating basis. What is the purpose of administrative staff? Most of the boards and commissions have administrative staff. The purpose is basically to make sure the agenda is compiled, make sure the information is distributed, make sure the meetings are posted, make sure that the venue is been reserved, make sure that the minutes are done, make sure that the minutes are approved and posted subsequent to the meeting. Just some of the important elements of what an administrative assistant does. Where is it appropriate to hold a meeting? It is generally most appropriate to hold a meeting in a public venue. A town building is much preferred over any other location. It is frowned upon to hold a meeting in a place where people would feel uncomfortable going, like a private home, or even that creating the perception that it may be something that's being done in secret. Why do we have public records from our meetings? Public records are required of boards and commissions to keep an accurate record of what the discussion was at the meeting. It's included in that, but not limited to the minutes, but also distributed, whatever materials have been distributed at the meeting. Minutes are generally a summary of the issues that were discussed and that had been posted in the meeting. And all votes that had been taken at the meeting are to be recorded. Once the minutes have been adopted by the committee subsequent at another meeting in open session, they are then supposed to be sent to the town clerk and posted on the website. Any questions? Again, I direct you to take a look at this appointed committee handbook. Has much more material than I just covered, but it's a good source of information. And give us any feedback on this as you go through it, because it's a first issue that we've had. If you see anything that's questionable or you don't quite understand, we'd like to go forward in the future and make some adjustments and revisions and get it there, so when we have another meeting like this in the future, we can distribute a revised version. Thanks.
Thank you, Mike. So our next presentation will be from Lauren Goldberg, who's a municipal attorney with Copeland and Page, and I'm gonna welcome you up, Lauren.
I'm shorter. Well, good evening, everyone, and I guess the bad weather outside makes it a little more pleasant to be inside, becoming familiar with the open meeting and conflict of interest laws. We did a presentation last night in a town in the northern part of the state, and my understanding is that they all said, gosh, that really wasn't that exciting, and the town administrator said, really can't make it exciting. But we're gonna try, both Brian and I. So while we get that going, I can just talk a little bit about what the open meeting law is. How many of you already serve on a board or committee? All right, good. So you all know, the open meeting law's intent is essentially, as the town administrator indicated, to provide for transparency with respect to governmental decision making. The public records law and the conflict of interest law, together with the open meeting law, are essentially known as sunshine laws. Has anyone heard that term? There's a week in the spring when the newspaper community does all sorts of public records requests and attends meetings, and they're looking to see is government operating in a transparent manner in accordance with law. The open meeting law in Massachusetts was redone several years ago, became effective in July of 2010. And so although that seems like a long time ago in some ways, in other ways we're still getting used to some of the requirements of the law. In terms of enforcement, and this is really one of the biggest changes in the law, it all moved to the Attorney General. And before that, it was by the various district attorneys. And the district attorneys were more familiar with the different communities. They had kind of a sense of the way communities operated, and many of the open meeting law issues that the Attorney General now deals with, thank you, was many of the things that they deal with now were things that the district attorneys tried to address without making findings against municipalities, findings of violations. However, since the Attorney General took over, it is much more likely that a community or a board that doesn't comply strictly with the law will actually have a finding against them. And that's tough for municipal boards and committees, most of whom are staffed by or filled by volunteers, because in our experience, open meeting law violations are, for the vast majority, simply a misunderstanding of the way the law applies, or not even knowing that the law applies. So the first thing is to ask, what does the law apply to? And the law applies to meetings. Now, there's definitions in the law that are kind of dependent on understanding other defined terms. So, well, what's a meeting? A meeting is a deliberation by a public body with respect to any matter within its jurisdiction. So what's a deliberation? Well, that's a discussion amongst a quorum of the body. And a quorum is further defined, because of course lawyers wrote this law, to include a majority of all of the members of that committee. So that doesn't mean a majority of those then in office, and the town administrator mentioned if there's a vacancy, that doesn't change the quorum. And so it makes it harder for the board or committee to operate. If you have a 5-member board and you have a vacancy, you have 4 people that can make up a quorum. You need 3 at least to show up at every meeting because that's the quorum of the board. So vacancies really do have an impact on the ability of a board to do its work. So a meeting is a quorum of a public body getting together to talk about matters within its jurisdiction, okay? Now, there are some exceptions to the definition, and again, I'll go back to a lawyer wrote this, but they're actually practical things that were coming up over and over again in practice throughout the state that the committee that wrote this law took into account. So one is an on-site inspection. Can anyone think why an on-site inspection wouldn't be a meeting for purposes of law? I know that Dottie knows the answer to this because I've done this presentation to the clerks. The reason is that we can't invite people onto private property just because we feel like it, and it's not accessible in many, many cases. So if you go on a site inspection at someone's home to look at the potential cutting that they're looking to do in their backyard, it's not accessible, it's not handicap accessible. So we can't have a meeting there because all meetings have to be in accessible locations, and as the town administrator said, preferably in a public building. Okay? So an on-site inspection is not a meeting. Neither is attendance of a quorum at a conference or training program like this, or at a media, social, or other event. And that's specifically in the law. So you can all go to, if you're on the school committee, you can all go to the school committee conference. If you're the Board of Selectmen and you all want to go to the Mass Municipal Association annual meeting, you can do that without violating the law. In large part, though, I think this might have been a result of Christmas parties being a problem, especially in small towns. You happen to know other people, you all go and you wind up at a party. What are you supposed to do? We continue to say you should not gather. The Conservation Commission shouldn't gather in the kitchen and huddle up because it looks like you're talking about government business, but it's not a violation of the law to be present. Other things like signing documents may take place out of a meeting when the terms have previously been discussed and voted on at an open meeting. So if you come in, for example, I can use the Board of Selectmen and the warrant for a town meeting. If the Board of Selectmen votes that warrant at an open meeting, and Mike says, I'm gonna prepare that for you, you can come in tomorrow and sign it, that's not a meeting. All they're doing is ministerially putting their names on the warrant. It's already been voted in the format that it's been approved. So those are the exceptions. What you can't do at those meetings, at those events, is deliberate. So you can't actually make decisions at those types of non-meetings. So there's some practical considerations we're thinking about, especially for land use boards. These turned out to be really important. Post a follow-up meeting. If the members anticipate that they're going to need to talk about things, or if you're a board that likes to talk right away about things, best to post a meeting for right afterwards and just go to that meeting and talk at the meeting about what happened at the site visit. And at the site visit, you could say something like, I'd like everyone to look over there at that pile of branches. You wouldn't say, because I have a real concern that that violates the Wetlands Protection Act and our bylaw because it's within the buffer zone. That part is really deliberation. The first part, could everyone look over there? That's not deliberation. So having that discussion would then look something like, remember when I asked you to look at that pile of branches? Well, I have a great concern that that's blah, 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 and that's how you take care of that. Other issues, don't drive to a meeting together, to a non-meeting, I should say, together, sit together at that non-meeting or talk to each other, okay? Why is that? Why do you think? Again, it's kind of, it sets a bad tone. It makes it look like you're deliberating, and even if you wouldn't normally think that you might, if someone's up at the podium and they're talking and they're making a really good point and you look to your left and Brian and Dottie and I are on a committee together of 3, and I turn to them and I say, right, do you hear this? This is exactly what we've been saying. When I do that, as innocuous as that seems, I've now violated the open meeting law. We're deliberating amongst a quorum outside of a posted meeting. If a member wishes to speak, and again, this point was made very well by the town administrator, you have to be clear that you're speaking on your own behalf, that you're not representing the board, okay? And particularly if you stand up about something that you're excited about or that your board is dealing with, you don't want to turn to your board and committee members and say, right, don't you think? Isn't that what we've been saying? Because by doing that, that's a deliberation. Now, in a practical world, that seems very likely to happen. So that's a good reason not to sit with your people from your board or committee. It's harder to reach out to them in the crowd to get their confirmation. And then another option is if you're going to go to a meeting of another board or committee, which you can do as long as it's posted, and that board or committee is going to be dealing with something that's important to your board, you could think about posting a meeting instead, a joint meeting. And that way, if you want to weigh in, or if your board or committee wants to weigh in, they can, without it being a violation. Okay? All right. Any questions about meetings or non-meetings, as the case may be? Okay. The next issue is deliberation. And a deliberation, and the main change in the new law is that it includes email, okay? So it's a written or oral communication through any medium, including email, between or among a quorum of a public body, a governmental body. So essentially, and this is a really difficult lesson to learn if you don't comply with the law on this, because the AG's office is not flexible when it comes to email, okay? If you're sending an email to a quorum of members and you share your ideas, feelings, beliefs, concerns, opinions, fears, whatever it is, anything beyond, Madam Chairperson, please include the following item in your agenda for next week, that's not a violation of the open meeting law. But saying, because this is so important to me, as you know, I'm a huge advocate for whatever, that because creates a violation of the open meeting law. And there's examples, and I gave you for your reading pleasure some examples of where the AG, they just flat out say it absolutely violates the law. So the other thing is that you cannot use a staff person to get around the law, or the staff person can't get around the law by saying, I'm going to ask every single member what they think and then tell them as I go. So I start off, let's say it's the 3 of us. If I'm the staff person and I start off by saying to myself, those that know me would laugh that I might talk to myself, because I might. If I say first to me, what do you think? Do you want to go forward with this really important issue at next week's meeting? I think there's a real value in getting out in front of this, da, da, da. And I say, I do. I think we should get out in front of that. This is too big a risk. And then the staff person goes to Brian and says, Lauren really thinks we need to get out in front of this. Da, da, da. Now we've started a violation of the open meeting law. The staff person can have independent conversations with each of us without violating the law, but it's sharing that opinion, person to person to person, that creates a violation. If this seems overly technical, I promise you, I did not write the law. I wasn't asked to weigh in on it. It is overly technical. All right, so Wayland, unfortunately, has been the subject of a number of violations. So I gave you some examples. And this is, even if you don't reply to the email from a board member that says, I feel, I think, I wish, even then it's still a violation. So here is the AG's advice. Our best advice continues to be that public bodies not communicate over email at all, except for distributing meeting agendas, scheduling meetings, and distributing documents created by non-members to be discussed at meetings. If your town council writes you a letter, then the chair of your board or committee can forward that to you without violating the open meeting law. If the chair of the committee writes a letter or a memo and shares that with the rest of the members, that creates a violation of the open meeting law. Now, I should have started off by saying this, but I'm going to remind you now. There's a difference between what we're talking about, which are best practices, and what might be defensible under the open meeting law. Your town council's job is, it's a dual responsibility. One is to say, here's the best practice, here's the way to avoid violating the law, but there are also times when town council has to advocate on behalf of the client to argue that something that happened was not actually a violation. So you might see in letters that your town council might write why an alleged violation was not actually a violation, and at the same time, town council might say to you, but please don't do that because it doesn't look good or it creates the opportunity for a violation. So there is a difference. We're talking about best practices, okay? Because this is a perfect example. That's their best advice, that you don't use email for anything but these limited things, but there may be additional uses of email that don't violate the law, okay? All right, so electronic participation. This is new and it is not specifically addressed in the law. It took the open meeting law about, 10, 15 years to catch up with the use of email. So we've got, we only recently started using blogs and Facebook and instant messaging and Google Groups. And so those things have become an issue under the open meeting law as well. It doesn't specifically say so, but unlike in the previous version of the law where each district attorney would be likely to and did interpret the law differently, here we have just the Attorney General. And we know the Attorney General interprets the law in a conservative manner, meaning in a strict manner. So there is significant risk. We say it also appears to implicate the open meeting law because there's arguments about that, but the best case scenario for board and committee members is to try to avoid weighing in on subject matters of their board or committee on a Facebook page or a personal blog where other people are involved. Now, that's a perfect example of reality, practical reality, and the open meeting law maybe not working exactly or seeing eye to eye. Because a lot of people, especially elected officials, run for office based on their particular viewpoints. And so, they're out there on Facebook all the time saying, this is our biggest issue, we have to deal with this today. If they are then friends, like I'll use Facebook as the example, if they're friends with all the other members of their board on Facebook, and then someone else jumps in and says, me too, this is exactly how I feel, and a third person does on a 5-member board, we get to a quorum. Is that something that violates the open meeting law? It's not 100% clear, but it's good to be aware of it, and if you're looking to avoid creating the appearance of a violation, don't get involved in that. You can watch it happen on Facebook without weighing in on it. Okay. So what are types of things that lead to potentials for violation? An email, voicemail, instant message, posting, or blog originally addressed to one person on a public body that's forwarded to or invited or reviewed by a quorum of the members, okay? So a serial violation is a real thing, okay? It might just be between, if there's a 5-member board and you just have an email with one member, that doesn't in and of itself violate the open meeting law. But as soon as it's forwarded to a third person, now it violates the open meeting law. It's a serial violation, okay? And you can have a serial verbal violation. I talk to Brian on a 5-member board, Brian talks to Dottie, now we get to 3 out of 5, it's a violation. We have one of the founding members of our firm who recently retired. When she was out at these training sessions, she would always say, so you can't talk about the substance of any matter with the other members of your board outside a meeting. And I would always say to her, gosh, that isn't 100% true. And she'd say, yes, it is. It's the best truth that there is, because that way you never violate the law. So there's a real plus side to not talking to other members of your board or committee outside of a public meeting about matters that are within your jurisdiction. There's also other implications for that, including due process considerations, if in fact it relates to a matter that's the subject of a public hearing, okay? Public hearings, there are due process protections to the applicants, and so having a conversation outside of that public hearing process can also create a potential for a challenge. Maybe this is doom and gloom day. I don't mean it like that, but it's important to think about that. Also, web-based discussion groups, those are problematic. You cannot write a decision using a web-based discussion group. You can't hash out the issues using web-based discussion group. You have to do that at a meeting, okay? All right, so in terms of avoiding violating the open meeting law, using email, don't ask for or express opinions, ideas, beliefs in an email to your other members. Don't click on reply to all. I like to think of that as the, flashing red button. Pretend it doesn't exist. If you only reply to the sender, the chances of you violating the open meeting law are much, much smaller, okay? If you feel you cannot contain yourself and you have to weigh in, send it to the staff person. Let them be the recipient of your outrage. That way you're minimizing the possibility of a violation, because as soon as you share your feelings, you violated the law. And as soon as anyone else responds, now there's more violations of the law. So it really creates a chain reaction. Yes?
The receipt of that serial chain, is that, the recipient in violation of open meeting?
Well, that's very...
In the passive, essentially.
It's a very good question. So one of the things that the town administrator pointed out, and I was giving him huge points while he was talking, is that boards and committees really only act as a body. So individuals, it's hard for an individual to violate the open meeting law. Typically, it's the board that violated the law, even if an individual was the one responsible for sending, and even if no one else replied. The AG has actually issued a few opinions where they say it was the individual violated the law. And we were somewhat puzzled by that because it's difficult to see how that could be. But the fine, if there was a fine issued against the town for the violation, it wouldn't be against the individual, it's against the board, the town. So the best answer that I can give you is to say, whatever you do, don't reply. The sending of it creates the violation for the entire board, even if an individual is responsible, okay? And I do think that board and committee members are at a bit of a disadvantage, and Brian will talk about it in the context of the conflict of interest law as well, because there's very little you can do. If someone's already sent you the email, you can't make them take it back. You know, it's not playground time, you know, take that back. No, you take it back. Because once it's sent, it's sent. But as a board, you can have a discussion as to what the email practices are and why they're risky or not risky and what's the best procedure. In some towns and in some boards, I know the members of the board do not converse by email at all. They take the Attorney General's advice and only the staff person sends things back and forth. And that truly does reduce the chance of a violation. Normally someone from the crowd would say, yeah, but this is 2016 and we do all of our stuff by email. And so there is a real dissonance between regular practices in your day-to-day life and your day job, or your regular social life and how you deal with this open meeting law issues as a member of a public body. Okay, so what is a public body? Anybody who is, we already did that. Any multiple member body of the town is a public body. So if it's in the bylaws, in the charter, in the statute, a vote of town meeting that creates a body, that's a multiple member body. But it also includes a subcommittee. So that's a multiple member body that's created by the parent body. That subcommittee could be less than a quorum of the actual parent body. So let's just take a 5-member board. We make a subcommittee of 2 to to have other, and I can think back to the charter times, to have other members of other town administrators or other members of the Board of Selectmen in other towns come in and talk about their form of government. And those 2 people would be able to sit there at a posted meeting, hear what people had to say. That's a subcommittee. But the subcommittee could also include other people, so other either residents or other town staff or whatever, that could create a bigger committee. So it could have 1 member of that board or committee on it and 6 other members, or it could have no members of the board or committee. A subcommittee is a multiple member body created by the parent body for whatever purpose. And it doesn't matter if it's just advisory, they're still subject to the open meeting law. There is an exception to the rule, again, because lawyers wrote this, and that is what's called the Connolly rule because of the case that the rule was established by. And essentially what it says is if a single individual has authority under a statute or a charter or a bylaw to do something all by themselves, and they want to appoint a committee to help them, that committee is not subject to the open meeting law because it's not a committee of a committee, it's a committee of one person. So if the town administrator has the authority to do something under the charter, he may appoint a committee to assist him, and that committee is not subject to the open meeting law. You typically see this, superintendents might have committees, a town administrator or manager might have a committee, and other than that, there's not a lot of people that are independently imbued with statutory authority or authority under the charter to accomplish something, okay? Okay, so the big issue here is not what the committee looks like, but who created it. So it doesn't matter if it's a formal creation, you are hereby charged with blah, 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 or if the board of committee says, we really need some help on this. Could you and you help us out? That's enough to create a committee. You're authorized, you're appointed by a governmental body, and you're authorized to act collectively. The example I give is essentially what was a department head group that was appointed by the Board of Selectmen, in this case to review the bylaws. So because the Board of Selectmen appointed all of these department heads and said, and now you are a committee, go about your business, that was now a committee that had to post under the open meeting law and was subject to the open meeting law. Minutes, posting, everything about it. If that same group had not been appointed by the Board of Selectmen, but instead the town administrator said, hey, you department heads, we need to get together every couple of weeks and take a look at these bylaws because they're a wreck. If that happened, that committee, that group, is not subject to the open meeting law. It's not a committee, okay? Marshfield, there was a case where the AG said that a group of citizens assembled by a special town council to advise on proposed bylaw changes was not a public body. They weren't assigned to any particular charge, they weren't empowered to act collectively, there was no quorum requirement. It's basically like an open house. Anybody who wants to come, we're gonna sit around, we're gonna talk about these things. That was not a committee for purposes of the open meeting law. Okay, so now we get to notice. So the notice provisions are very important. You may not have a meeting of a governmental body unless notice of that meeting is posted at least 48 hours ahead of time, excluding Saturdays, Sundays, and legal holidays. The difference between the old open meeting law and the new one is that it includes Saturdays. So it really forces people to be much more organized if they want to hold a meeting on Monday. That's really what it comes down to. You got to post on Thursday, you can't post on Friday. So that is the big change. The notice for the meeting has to have the date and time that the notice is posted, that the meeting will be held and that the notice is posted. And that's so that we can verify the 48 hours, okay? That also is not in the old open meeting law. If revised, the notice has to also say, or updated, it has to say when it was updated, date and time, and also what's new on that meeting notice. Okay, so this issue is very administrative. It's very kind of down into the weeds in terms of the details, but it's an absolute necessity. If someone wants to make trouble for a particular board and committee and it's not doing this, the work that committee does can be undone by the filing of an open meeting law complaint. The open meeting law does not say what time a particular board or committee has to meet, but they do encourage public bodies to meet at times when most people will be available. And I actually think that doesn't do a great job of explaining. In some towns, it's the norm to have meetings at 7 o'clock in the morning. People work, they leave the town, by 8 o'clock, they're gone from town and they don't come back until well after rush hour empties out and people are able to come and go. In those towns, 7 a.m. that's a fine time to have a meeting. And same thing the other way. There's lots and lots of towns where they'll post a meeting for 9 p.m. because that's when people are typically able to get there. And that is fine. Meetings can go as late as they need to. You don't have to change your meeting schedule because of a complaint. But this is what the AG says is a best practice. Okay? If you held your meeting at 3 in the morning, eyebrows will be raised. Okay, so how do you post? You post with the town clerk in a manner that's conspicuously visible to the public at all hours. In or on the municipal building housing the clerk's office, which essentially equates now to the website, although there's many, many towns that ran out after the AG first started asking or interpreting the law and said it had to be outside. So they went out and they got a glass container. Did you guys get a glass container? No. Okay. So the website is an appropriate posting location, and that is in fact where your board has voted to have that additional posting. It's also on the town clerk's bulletin board. Now, we'll go back and talk about that in 1 second, but another important development in the new open meeting law based on the AG's interpretation is that you cannot continue a meeting from one night to the next if that second night is not posted. And this was one of those things that was different county by county. Now it is for everyone. So if you're holding a meeting on Tuesday night and you don't get through with your agenda and you say, it's ridiculous, we're gonna have to come back tomorrow, The only way you can come back tomorrow is if your meeting was properly posted, okay? So you have to post that second night's meeting, but you can't post 5 nights a week and, each time put the same agenda up and then cancel, just use the one that's convenient. You have to actually think you're gonna need that date. If you wanna cancel the meeting because you don't need it, you can cancel it. But if you post it for 5 days and you cancel 4, basically the AG is gonna interpret that as you trying to kind of outsmart the populace so that they can't come to your meeting. Okay, so let's go on to what's an emergency. If you have an emergency, you don't need to comply with the 48 hours. Typically, an emergency is something that is a threat to the public health or safety. A house that's about to fall down, an ocean that's about to cover, or that is covering the main road, a snowstorm that prevents people from getting out. A filing deadline, a man-made emergency, is typically not an emergency for purposes of the law. What do you need to do? You need to post as soon as you can. You need to comply with the law to the extent possible. So, because we have a town clerk here, I'll use my town clerk example, which is in one of our North Shore towns, there was a giant snowstorm on April 1st, I think back in the year 2000. Enormous, huge. And so lots of cities and towns were having issues, with should they cancel their elections. But in this one town, they couldn't even get out of their homes to have this conversation to get to town hall because the road had flooded. So what were they supposed to do? They could call each other on the telephone and have a conference call. That was sufficient for the open meeting law. That's the best they could do. It would have been dangerous to go outside. On the other hand, if you have a house that's been about to fall down for a whole year and the building inspector goes out and says, all right, now this is it. We can't wait another day. Then you could go in and have this meeting without waiting the 48 hours. But you'd actually have to go to town hall or to the publicly posted location because there's no emergency that would keep you from doing that part, okay? Even my example of the selectmen on the phone deciding whether to cancel the election, they still had to keep minutes of that meeting, all right? Other good things to remember is you can't talk about other things. You can only talk about the emergency. You have to take minutes, and you have to review and include those minutes in the minutes of the next regularly scheduled meeting. And what I always suggest is that when you're posting an emergency meeting, if you're able to do so, that you post a regular meeting as well, as soon as you can hold it, so that you can ratify, validate, and confirm that the action that was taken at that earlier meeting, and that if people want to hear what was discussed, they have the ability to hear that as soon as possible. All right, so what does the notice look like? Under the new open meeting law, it says that a notice has to include a quote-unquote listing of topics that the chair reasonably anticipates will be discussed. To us, and I think to a lot of municipal officials and throughout the state, a listing of topics sounded like, renew annual permits, address concerns regarding compliance with the open meeting law, issue licenses for, for soil permits, or soil licenses, soil removal. The AG interprets the law very differently, and one thing we do know after 6 years of the Attorney General's interpretations is that what they intend is for the items to be discussed, that the items will be listed. So rather than fall soil permits, approved fall soil permits, they want each and every permit to be listed separately, the name of the applicant and the address of the related application. So that looks very different, okay? Instead of, water superintendent update, it will actually say, report on the following 5 things that were of issue or at issue that week. So that was a significant difference from the prior law, which really required only that you post the time, date, and place of your meeting. So you have to post with sufficient specificity for someone who's not going to attend to make the decision about what they want to. For those of you who go to town meeting or are involved in reading a town meeting warrant, it's like the opposite of the town meeting warrant. That's more like notice of kind of the ideas that are going to be discussed, and this is like getting to town meeting and hearing what they say. Exactly what the motion is, exactly what the people are going to say at the meeting. It's a roadmap of the discussion. If an executive session is planned, it has to actually say so on the agenda, and it also has to say if all you're going to do is have an open session meeting, an executive session meeting, it has to also say that, So it would say like open meeting and open session, and then executive session with the statutory site and the purpose for the session. They are not fooling around. Here are a few of my friends from Wayland. And so those are, you couldn't say new business, old business, and invoice approval, just that information. If you knew what the new business, old business, and invoices were, you had to list them, okay? So it could still say new business, but underneath it would have the particular items. And then, all right, so that's that. So there are some practical implications of this process. If the chair does not reasonably anticipate a particular matter, and the mechanism for thinking about whether something's reasonably anticipated is really like, did the chair know? Did the chair have reason to know? Did someone tell him, I'm gonna raise this? And the chair said, there's no way you're raising that, I'm not putting that on the agenda, then that matter shouldn't be discussed at the meeting. If the chair did not have reason to know and someone brings it up, then it can be discussed at the meeting. It's not prohibited. The AG recommends that unless the matter requires immediate action, and especially if it's controversial or important, that it be put off to the next meeting. And again, this is a difference between best practices and what's legal. It's legal to talk and decide about anything that comes up at the meeting as long as the chair didn't reasonably anticipate it. That's not what's recommended. Okay? So if a matter is brought to the attention of the chair after the notice has been posted, meaning after the 48 hours, you can still update that notice, and you ought to if there's a time and ability to do so. There could be a policy about that, but you need to know the time and content of the update. It's been very useful in other communities to kind of have a procedure in place for that. We will put anything that's updated in bold, we'll put 2 stars next to it and an explanation. Anything starred in bold is new. It may not be possible to update though if the staff can't reach the chair, okay, or the chair isn't able to discover it immediately or in advance enough of the meeting. And we did see this in one of our towns where there was a federal grant that was dependent on being acted upon right away. The chair didn't anticipate it because under the original guidelines they had weeks left to act. The town administrator found out about it about 12, couldn't reach the chair on the phone, but they needed to act on it that night. They couldn't update. They acted on it that night. Of course, there was an open meeting law violation filed, but we were able to defend it successfully, saying there was no way that the chair would have known. Even though it was coming, they wouldn't have known right then. This is what I said about the AG. Strongly urges not to consider topics that may be controversial of particular interest. Okay, so what needs to be in the notice? The location of the meeting has to be in the notice. The location must be accessible, we already talked about. You really can only meet in a privately owned location if it's handicap accessible and open to the public. An example of this would be a senior care location. As long as there's an ability to use a common room and anybody who walks in the door can go to that common room, then you could use something like that. A church, something like that would be acceptable as long as it's handicapped accessible. If you have a big crowd and you need to move a meeting, that's not prohibited by the open meeting law, especially if it's within the building. Put a notice on the door, put a notice on the front door. You can go from one place to another. If, however, you have to go to a different building, you need to really think about what the chances are that someone might file a complaint and whether there'll be people that arrive at the original location who won't be able to get to the other one. Maybe they got dropped off, maybe there's special circumstances, so you need to anticipate that. Maybe leave a staff person at the first location to try and help arrange for rides, things of that nature. The other thing I want to point out is that you are not required to leave the door open if you're having a public meeting, but people need to know that they can come in. If you close the door, you need to put a sign on the door that says, open meeting, please enter. Okay, minutes of an open meeting are public records, and there's just a few exceptions for that we won't talk about. Public participation, I can't recall, is there a public participation rule? Is there anything in the charter that requires? Okay, so public participation is not required by the open meeting law. It doesn't appear to be required by your bylaws or charter. And so what that means is it's up to the board or committee to decide if they want to allow any participation by the public in its meetings. A lot of boards and committees do like to allow some because they think it's useful to them. But it's very important to understand that there's no inherent right. So this idea of the chair saying at the beginning, we're not gonna go back and forth, is exactly the advice that I would give. It's up to the chair to control the meeting, and if the chair is allowing people to go back and forth with each other or back and forth with board members, that meeting doesn't stay under control, number one. Number two, people respond to things that perhaps it would be better to think about. And number three, it can really change the tone and tenor of the board's meeting. So that's an important thing to consider. Okay, remote participation, I know that's been authorized by the Board of Selectmen. There are limited reasons for allowing remote participation. It's up to the chair. There's information, there's only certain reasons that you can actually use remote participation for, and many of those have to do with you're out of town, you're physically unwell, you know, there's some other personal reason that's prohibiting your participation. The chair does not have to say what that personal reason is, can say that they comply with the requirements of the regulations in their reason. And one of the things that we noted is, if you had to say that because they're out of town, well, now anybody would know that their home is empty. Or if it was that, you know, they've fallen and they've broken their leg, that's given out information that's personal, medical information, could be protected by HIPAA, it could be protected by just the regular rights to privacy. So that is important. Recordings under the new open meeting law, any person can record, same as always, but now the chair has to make an announcement that the meeting may be recorded or is being recorded. And that's because the state wiretap law said you can't record anyone without their permission, and the open meeting law says you can record any meeting you want. So now essentially the balance was, have the chair tell the people this meeting is being recorded. The chair has the right to say where that recording instrument is going to go. So if, you know, someone comes up and they're shoving a microphone in people's faces, the chair can certainly say, we're not going to do that. And I've actually been at meetings where that's happened. But the chair could say, for example, everyone could leave their recording instruments on the table, but couldn't make them go at the very back of the room, because then they wouldn't be able to record. So, you know, you have to be reasonable about the restriction, but it can be done. An individual is entitled to create their own independent record of an executive session. That wasn't in the old law, but it's in the new law. And I always say, if an individual is recording an executive session, so should the town. Normally, you don't have to record executive sessions, and often they are not. But if someone is recording and they're there recording, you want to record as well, okay? The notes that the board clerk takes are public records as of the moment of their creation. So sometimes you have an administrative assistant who's doing it. That administrative assistant's notes, that would be the minutes of the meeting until the minutes are formally approved. Public records as of the moment of their creation. I always suggest that whatever's written down not include any comments about whether someone likes someone or doesn't like someone, or if they use foul language or didn't use foul language. That's not the type of thing that we need to see in minutes. It's not a verbatim record, but a record of what was discussed at the meeting, and it has to be more significant than just saying, for example, discussion about the open meeting law. It would be, we focused on these 5 things, questions were asked about this or that, so something kind of in detail and length that are commensurate with the detail and length of the meeting, okay? Okay, so right now those minutes have to be provided within 10 days of the request, both for executive and open meeting minutes. If a body has not reviewed its executive session minutes, it has 10 days or the board's next meeting. If the review hasn't been done, it's the board's next meeting or 30 days, whichever occurs first. Okay, so there is a time limit. Executive session is a strictly regulated mechanism, and that is because, and I know my time is drawing to a close, so I'm going to try to be fast here, but that is because there's a presumption that all of the government's business has to occur in open session, okay? That the public is going to be able to witness it. There's a few legislative reasons that executive session is authorized, and really when you look at it, you can see what the point is. One is to protect personal privacy. Okay, so it's in cases where you're talking about a person's mental health, about their physical health, about their financial means, about their good or bad behavior, usually bad, or alleged bad behavior. It could be about employees, but it could also be about any person. Some towns have civil rights commissions, and so those are the types of things where you might go into executive session to deal with privacy, complaints or charges against individuals, okay? And so that's one of them. The other is to allow the town to act like a participant in the market. So for example, with respect to litigation strategy or collective bargaining strategy, or to act as a purchaser, or to evaluate the value of real property. In those circumstances, the law, the open meeting law, puts the individuals the town on the same level, the same playing field as others. And then the last one is essentially to allow the town to act like an employer, okay? Because there's times when the town is an employer as well. So to go into executive session, you have to follow the rules. And the rules essentially are, you have to have on your meeting notice the reason for your executive session. Put on that meeting notice the exact statute, the exact exemption that you're gonna rely on, the statutory citation, the language from the statute, and then the additional information that you can reveal without compromising the purpose of the session. So for example, if we were special counsel and we were handling a litigation matter, it would say, executive session, purpose 3 with the statutory cite, and then in addition, it would say to review strategy with respect to litigation, and then it would have the case name, okay? So that's an example. Under exemption 1, you don't have to say the person's name that you're going in to discuss, and that's the one where you're talking about a person's mental health or allegations, etc., because then you're not protecting their privacy, and that's the purpose for the executive session, okay? But pretty much everything else, you're gonna have other information there. The other thing you have to do is say whether the body's coming back out into open session, all right? So you don't have to do that on the meeting notice, but you have to say it. Now, we'll said we have some kind of cheat sheets for going into executive session in the process, so we'll send those over to Dottie and she can get those to you in case you need to. But really the only reason that boards and committees would go into executive session is, as I said, with respect to complaints or those financial things or eligibility for, let's say, for housing or for programs or something. With land use boards or other boards that grant licenses for the purpose of litigation strategy, and then to actually conduct negotiations if it's a board of selectmen on those things. And that's really, it's very limited use. So the public body has to limit its discussions in executive session to just what's on the meeting notice, okay? You can't just all of a sudden talk about other stuff, and I think as council, that's the thing we find the hardest, because we have to say when we're in these meetings, we're sorry, we're here, we can't really allow you to talk about other things, let's bring our attention back to the matter that we're dealing with. So that's a tough thing for a board to remember, and it's also uncomfortable for council. So you also need to make this declaration in many cases that that having an open session discussion would be detrimental to the position of the town. And in the cheat sheet that we send, it'll tell you which exemptions. So it's 3, 6, it's 3 and 6. So, as I said, if you anticipated, it goes on the meeting notice. If something arises at the very last minute that you have to go into executive session for and there's no time to update the meeting notice, just like we talked about, you have the ability to go in and deal with it if you needed to. And the vote has to match the notice in that it has to include all of the information that can be disclosed without compromising the position of the body. Typically, if your meeting notice is good, you can just read from your meeting notice and the chair can declare that going into executive session is necessary to avoid compromising the town's position. So minutes, time, date, place, members present and absent, a summary we talked about, decisions made and action taken, that's really every discussion, the record of the votes, and the list of documents and exhibits that were used at the meeting, the documents that were there, that were relied upon by the board, okay? That's really what the standard is, not just if you said, did anyone get a copy of the whatever, that comment doesn't all of a sudden mean that document has to be listed. Right, we talked about that. There's examples. We talked about time frame. The AG says that they would like you to approve open meeting minutes in a timely fashion. 1 month is timely under their estimation, 2 months is not. Ideally, they would like you to do it after every single meeting. First order of business at the next meeting. Okay. Executive session minutes can be withheld until the purpose of the meeting has expired. I'm late. Okay, the Attorney General. The Attorney General is now the enforcing authority. For those of you who've been unfortunate enough to receive a complaint, it has to be on a form filled out by the complainant that was prepared. The form itself is the AG's form. It has to be within 30 days of the date of the alleged violation, or 30 days from the date they found out about what they think the violation is. The public body has to include that item on a meeting notice and meet to decide how to resolve it. You can't just say, town administrator, please handle this for us. The board actually has to meet, okay? Once the board's met, it can then say, this is what's been raised, this is how we feel about it, we'd like, town council to take care of resolving this, and then that's fine, but they have to meet. If the complaint is 14 business days from the date of the complaint, which is nearly 3 weeks in business days, the complainant can then file a further complaint with the AG if they're not satisfied with the board's resolution of the complaint. When the AG gets it, the AG can essentially do almost anything they would like to remedy the violation, okay? They have broad authority. So it's very important to not give the opportunity for a complainant to continue to go to the AG to seek that kind of relief. Better for the board or committee to deal with that at the local level. If you discover you violated the open meeting law by an email chain that was forwarded to that third person, just put it on your own agenda, bring it up, and take care of it. And how do you take care of it? That's the concept of cure, which is the public body has to make an independent deliberative action and not merely ceremonial acceptance to ratify, validate, and confirm the action they took. So what they would say is, we discovered that we had this email chain. In that email chain, we discussed the value of swift action on matter X. We're going to talk about that today, and then we're going to vote to confirm our previous discussion. And so, you ask each person to essentially explain where they were coming from and why they felt like they did, and then you can take that vote. If the AG wants to impose a civil penalty, they have to hold a hearing, and they can impose a fine of up to $1,000. In our experience, towns will reach settlement agreements with the Attorney General where they don't pay the full $1,000, but they agree to do a training like this and pay a smaller amount. And anyone can go to court if they would like to enforce the open meeting law. The Attorney General can go to court. If a decision comes out that a town isn't comfortable with, they have 21 days from the date of the decision to challenge it in Superior Court. But the balance between the deference that the court's going to give the Attorney General and the deference that the court is likely to give the town is weighed heavily in favor of the Attorney General. So there's a risk with that. There are some defenses. One is to show that you complied with the law, and the other is an advice of counsel. Defense will protect you from the imposition of a civil penalty. So if you acted in good faith on the advice of counsel and the AG says, we don't think so, that wasn't what we would have wanted you to do, we think that's a violation, they cannot impose a fine if you had consulted with counsel. Here are some resources, and that is me. Thank you for your attention, I really appreciate it. And if there's further questions, certainly let Dottie know, and I'm happy to follow up. And thank you very much.
Thank you, Lauren. That was a great presentation. We never have enough time for Lauren's presentations. We have Attorney Brian Riley here from, now, is there a new name today?
Yes.
KP Law?
KP Law.
But I saw that in a late email today.
Yes.
So, KP Law. He'll be doing a presentation on conflict of interest.
Okay. I'm a little taller than Lauren. So thanks for having me here tonight. I'm gonna try to keep this pretty brief. For one thing, we don't want to keep you here all night, but also the conflict of interest law and some of the sections that I'll talk about, you can see they're pretty broad, and how it works depending on the facts of the situation can change dramatically depending on the facts. So it's kind of hard to make a lot of generalizations about this law, but we'll cover some of the basics. And things to watch out for. As the administrator said, complying with this law is sort of philosophically important because you want to put the town's interests ahead of your own or ahead of anybody else's when you're serving on a board or in an office. The other reason that it's important is that the conflict of interest law, unlike the open meeting law, has some real penalties behind it. The State Ethics Commission is the one who interprets and enforces it. And if they find that you violated certain sections and they think this was more than just sort of, whoops, you stumbled over it without really understanding what the prohibitions were, if they think maybe you had an idea and went ahead anyway, they can actually hand out penalties up to $10,000, and they're not particularly shy about doing so lately either. So, a little disclosure here, but also for the same reason. This is going to be very broad, kind of summaries of these sections and how it's going to apply to a situation you might see coming. You'll want to analyze it, you'll want to talk to your town council, or you can even call an attorney at the Ethics Commission. I'll talk about that at the end. So the conflict of interest law is in chapter 268A, and the State Ethics Commission, again, has issued some regulations. One of the handouts that I brought was a letter that we sent out about 5 years ago when the commission adopted a whole bunch of regulations. And I'm going to mention some of them, but that memo talks about some others. So 268A has I think it's got about 28 sections now, but some of them only apply to state employees, some only apply to county employees for the counties that are left now. And then there are some that apply to just municipal employees. These include section 3, 17, section 18 I actually don't have a slide on. That is restrictions that can apply to a former municipal employee. So you've got your position, then you resign, or your term expires and you don't get reappointed again. You might be some limitations on how things you can get involved in the private sector that you also worked on for the town. Those are pretty, those don't happen all that often, but just something when you do decide you're not gonna have your office anymore, just bear in mind if it's something that you also handle for the town. So the law applies to municipal employees, but unlike other uses of the word employee, this is not an employment situation. It doesn't matter if you're paid or not. The definition, as you can see, is very broad. You're performing any services for the town. Doesn't matter if you're compensated or not. Doesn't matter if you are appointed or elected. If you're you hold a seasonal position. All of those, or even a consultant. If let's say you're a civil engineer, you get hired by the planning board to do some peer review for 6 months. The engineer who's doing that for those 6 months is going to be subject to the conflict law. So it is very, very broad. The only two things which are written specifically out are members of a representative town meeting, which I know you don't have here, and members of an elected charter commission. So pretty much anybody else who's doing anything for the town needs to be aware of this. Oh, and I should mention that some of you who may be brand new to an office, there is a requirement. You'll want to check with Dottie's office. The Ethics Commission on their website has I usually call it a quiz, but you can't fail it. It's a training thing you have to go through and answer these multiple choice questions. It is just a training exercise, but you're required to do that within, I think, a month of when you take office, and you print out the certificate at the end and file it with the clerk's office. The Ethics Commission occasionally will check in and see how towns are keeping up on those. There are a couple of sections 17 and 20, that reference special municipal employees. These are positions that have been given that designation by vote of the Board of Selectmen. It's a discretionary call for the board. Some towns don't like to designate specials, others do. To be eligible, it either has to be an unpaid position, like the zoning board, the conservation commission, things that don't have any compensation at all, or if it's a part-time position that pays up to 800 hours or less per year. Those are eligible. They can just ask the selectmen to make that designation. The board, if they do, they're not approving the person who's in the job now, they're approving the position going forward as well. And it basically provides a couple of easier exemptions for them to do certain things. So when I get to those sections, I'll mention it. Section 19, which comes up all the time, about acting on something in which you or your immediate family have a financial interest. This is how immediate family is defined. It's not just you, the official, but it's your spouse and each of your parents, children, brothers, and sisters. Many things are, you can protect yourself from a violation by making a disclosure. The Ethics Commission has a whole bunch of forms that are pretty handy on their website. You have to put things in writing, file it either with your appointing authority or in some cases the town clerk. Elected officials have to file all their forms with the town clerk. And those are important to keep, to be aware of as well. Section 3, as I mentioned, Section 2 I don't put in here because it says you can't accept a gift, you can't accept anything of any value that's offered to you with corrupt intent, in other words, a bribe. So don't take any bribes, okay? That's Section 2. Section 3 is a little more complicated. You can't accept any gift of substantial value, which is the Ethics Commission defines as $50 or more, if given for or because of any official act performed or to be performed in your official capacity. So, so that does not have to be corrupt intent behind it. You may have helped out somebody who was trying to get through a complicated permit process, and they're very pleased with all the service you gave them, and they want to give you this $100 bottle of wine. Well, unfortunately, you should say no. There's no, there's no bad intent behind that, but obviously it's being offered to you because you hold this position with the town, and so you're not going to be able to take that. Some of the regulations the commission adopted said that if it's a gift that's worth less than $50, you can accept it, but you should make a written disclosure, file it with your appointing authority, or with the clerk's office perhaps. If it's a gift that's completely, if it's a birthday present, even if it's somebody who doesn't work for the town or your office mates, that's obviously not given because you are work in the assessor's office. It's given because they're your friends. So that's fine if you win a raffle prize of some conference you went to with boards from all the towns. That wasn't given to you for any purpose like that. So that's okay. Okay, well, I'll mention 23B3 in a minute, but that's about the disclosures for certain gifts. The regulations also pointed out some things which kind of look like gifts, things you're getting because of your public office, but which they have decided are fine. And those include travel expenses. You may be a department head and somebody who wants to sell you this $500,000 piece of equipment wants to fly you down to Philadelphia to take a look at one that's in operation, and they're willing to do that. You can accept that. It's not a bribe. It is related to your job, so you can go down and assess this equipment. So if it meets all those things and you kind of file a disclosure and there's a record with the treasurer's office and things, that's okay. Training events and conferences, maybe the town is paying for that anyway, but if somebody's offering to, let you come to this conference, or maybe they want you to even speak, those kinds of expenses are gonna be okay. Incidental hospitality, the cost of refreshments that are there. If, again, it's a legitimate public purpose related to your office, in general, you're not gonna have to worry about a disclosure or anything on that for those kind of things. All right, we'll jump into sort of the meat of the things for municipal employees. Section 17 has two parts to it. One says you can't receive compensation from anyone other than the town, or act as an agent or attorney for anyone other than the town, whether you're compensated or not, with relation to a particular matter in which the town is a party or has a direct and substantial interest. And so if a company you work for, you have you're on a board, so you're a municipal employee, the company you work for has a contract with the town, and you're gonna be heavily involved in it, that's an example of where you're gonna run into Section 17 problems, because you may be getting paid directly related to that contract by the company, so you're getting paid by somebody else. And if you are corresponding or appearing before town boards, you're acting as an agent for that company. So a lot of times, you're not gonna be able to do that. If special municipal employees, again, if you have that designation, these prohibitions only apply if you would have to go in front of your own board. If you're on the Conservation Commission and you're gonna represent somebody in front of the commission, you can't do it even if you are a special. Attorneys run into this a lot if they are, they're serving on a board or in some office, and then they have a client and they wanna go appear before the planning board on behalf of their client. They probably can't do that unless perhaps they have a special employee position. And the purpose of this is, they don't want you wearing two hats like this. Again, you're supposed to be looking out for the town's interests, and if you're getting paid by some client and lobbying to get them what they want, it's not gonna look like you're doing that. Acting as an agent, it's not defined, but this commission has kind of developed that over the time. It doesn't have to be as formal as, an attorney being hired by a client. Obviously, that one is covered. But it's almost any instance where you're representing somebody besides yourself. And it includes, signing a letter that goes to the town on behalf of somebody else, making a phone call, trying to be a liaison between, maybe your neighbor, trying to guide them through the process and be their mouthpiece, so to speak, before the town. That might trigger it. Even serving as a spokesperson, you may have kind of a neighborhood group, very informal, but the neighbors are upset about this project which just got proposed next door. And they get together and they wanna go to the selectmen's meeting and voice their concerns. They may look to you and say, well, you know how town government works, you be our spokesperson. That can be acting as an agent, even for something as informal as that. So you'll need to watch out for that. You can, in that group, we'll use that example again, you can help everybody else, you can help draw up the bullet points and all of that. Behind the scenes, just don't be the mouthpiece. It is only if you're representing somebody else. And there's the compensation aspect as well. One specific one which has comes up occasionally is you have people who are involved in a particular aspect of the town government, and then they may also be involved with a Friends of the Public Library, and they might also want to be a library trustee. That can be a problem because the Friends of, it's a corporation. If you're a library trustee and you want to, send a letter to the on behalf of this Friends of organization to the town, you're acting as an agent for that. There is one of the regulations the commission adopted says that if a board can designate one member to be its representative on a nonprofit board, that actually they'll give you a pass on Section 17 problems there. You don't have to worry so much about what hat you're wearing when you have a conversation. You can't always advocate for yourself. So as an example, somebody who has a town position, even if you're on the Board of Assessors, you may decide you want to apply for a tax abatement. You can do that. You can file your abatement. You can even sit on the other side of the table from your fellow assessors and explain why you think you should get an abatement. You're representing yourself. You're always allowed to do that. It gets a little dicey if the property that you own is held by a realty trust, which happens a lot, because then you're kind of speaking on behalf of the trust and not yourself. But in general, you're always allowed to represent your own personal interests or the interests of your family. Okay, Section 19 is one that comes up a lot, and what it says is that it doesn't matter if you're appointed, elected, special, or otherwise, you're not allowed to participate officially in any matter in which you, your immediate family, or your business or employer has a financial interest. And it makes no difference what the size of the financial interest is. There's no threshold. And so you'll need to watch what's coming across your desk and whether you can participate or not. If you're an appointed official and you know something's coming, you can make a written disclosure to your appointing authority. Say, you know, there's an application coming to my board. The company that I work for is gonna be a consultant, so, you know, they have a contract with this applicant. But I think I can still be objective. You know, if your appointing authority agrees with you and is willing to also sign that disclosure form saying, I don't think this is gonna affect the integrity of the services to the town, then you can participate. Elected officials don't have that kind of thing. And so if you're in a situation like that, the only thing you can do is step away from the table. You just can't participate. Occasionally you have a situation where 2 members out of a 3-member board have a conflict and can't act on it. There is a rule of necessity, which was created by the courts. You make disclosures and then all 3 of you can participate, but the Ethics Commission really doesn't like people to use that. It's gotta be an absolute last resort. So section 19 things come up all the time in our office, and you just have to be aware. There are some other funny wrinkles, like the Ethics Commission has said, and this is not in the statute or the regulations anywhere, if the thing that lands on your desk involves real property that is abutting your own or your immediate family members, we're just gonna deem that you have a financial interest in that, unless you can prove through an appraisal that you don't. We're gonna consider you have a financial interest in that because it's property next to yours, and you may be prohibited from participating. Section 20 is pretty much the worst section there. It's extremely long. What it says at the beginning sounds not so bad. You may not have a financial interest in a contract with the town unless you qualify for one of the exemptions. There are a ton of exemptions. I can't go through them all. But again, they are very fact specific. It's a lot easier if you're a special municipal employee. So for example, you might, let's say you have a little business on the side that sells cleaning supplies and you'd like to bid on a contract with the school department. If you're a special employee and you're not in the school department, it's pretty easy. You get the contract, you fill out a disclosure that you have it, and you file it with the clerk's office. If you actually work for the school department, you might still be able to get that, but you have to get the Board of Selectmen to vote to approve your exemption as well. There's some that make it easier to be like a call firefighter, or a part-time public safety or EMS position. Let's see. But, and the other important thing is it comes up if you hold a position, whether it's paid or not, and then you're interested in a, let's say a part-time paid position, town can't find somebody to fill it, you're willing to do it. Well, that's a contract. If it's a paid position that's not elected, it's considered a contract, and so in order to take that second position, you're gonna have to see if you qualify for one of these exemptions. If you're not a special employee, if you're just a regular employee, and you wanna see if you qualify for a contract, you have to meet 20B, which has all these different parts to it. It can't be in the same department or agency where your town position is. It has to be a public notice, and public bidding if applicable. You have to file a disclosure with the town clerk. If it's for personal services, in other words, a second position with the town, it has to be outside the normal hours of your first position. You can't get paid for more than 500 hours. The head of the department has to say, this is a real job, we really need somebody, and the Board of Selectmen has to vote to approve it. So people don't like using that, but sometimes that's your only choice. This one, just briefly, it used to be that if you had a paid position and let's say you wanted to volunteer to be appointed to the Conservation Commission because they had a vacancy, nice thing to do, help out the town. So you get appointed to that. Well, that's unpaid, so that itself doesn't trigger Section 20 as a contract. But once you're appointed, it used to be that you now need an exemption in order to keep your paid position, which is kind of crazy and really discouraged people from volunteering. So thankfully, this is the best thing the Ethics Commission did on these, I think. They adopted this regulation which says if you have a paid position with the town first, you can get appointed to an uncompensated position and not have to worry about Section 20. Not compensated, however, means there's no compensation even offered. You can't say, this position pays a $500 stipend a year, I just won't take it. It's still a compensated position, so you couldn't use this regulation. Crazy, crazy stuff. And the other one is section 23, which is called the Code of Conduct section, so things that weren't addressed in some of the other sections, kind of a catch-all. The two most common sections of it, subsections to be aware of, are 23B2. You can't use your public office or attempt to use your public office in order to gain an unwarranted privilege of substantial value, that's the $50 again, for yourself or for anybody else that's not properly available to similarly situated individuals. So basically means you can't use your office to try to get some favor, get something which wouldn't be offered to the general public, or things like if you're a selectman and you get pulled over for speeding, you can't use your office to kind of shake your finger at the police officer and say, do you know who I am? I'm a selectman. You can't give me this. Don't give me this ticket. I wish I was making up that example. That actually is from a case that the Ethics Commission had. But that's one example of using your office improperly. And then 23B3, you don't act in a manner which would cause a reasonable person with knowledge of the facts to conclude that you're acting with bias or favoritism or for personal reasons. So an example of that is, let's say, if you had an application comes to you and it's filed by your brother, that's your immediate family, he's got a financial interest in it, you can't touch it. Now let's say instead, it's filed by your best friend since high school, and everybody knows you're best friends. You go on vacations together and what have you. Well, you're certainly not prohibited by Section 19, but you might be concerned that people are going to question the integrity. How objective are you really going to be on this application? But maybe you're the only person who can act on it, or maybe you like to do it and you're confident that you can act on it. You can file a written disclosure, either with your appointing authority or the town clerk. Just disclose what the facts are. This is applications from Joe Smith. We've been friends for 20 years. I'm going to treat his application objectively like all the other ones. Once you make that disclosure, then even if somebody complains later that it looked, they don't think you should have done this, it didn't look right. If you made this disclosure, and all these disclosures are public records, it's not a violation of that section. Just a couple of examples of improper use of your office. These COI-12-1, these are advisories that the Ethics Commission puts out periodically once or twice a year. This one was about municipal employees engaging in fundraising on behalf of the town. Maybe you're trying to raise money to put an addition on the library or what have you. That's okay. The money has to get handled in a public account through the treasurer. You can't use any overt pressure on people to do it, and supposed to keep a name, and and avoid anything in that fundraising that would be inherently coercive. So let's say you work for a department that does annual permitting, fire department, building, whatever else it might be. And you are going to fundraise from somebody, and they know that next month you're going to be back again to inspect their property. You'd have to be careful of that situation, because that might make them uncomfortable. They might feel they have to make a donation. So that's the kind of inherently coercive thing that the Ethics Commission could say, that's one solicitation you shouldn't have done. This is just another one about improper use of your office. If somebody asks you to send them an official letter of recommendation for a job they're applying for, if it's somebody who used to work for you, and that's why they're coming to you for a reference, go ahead and use your town letterhead. They work for the town. It's acceptable, the Ethics Commission says, to give them that kind of formal recommendation. If it's just a member of your family or somebody who's a friend, and they want you to give them a reference, the Ethics Commission says, don't use your town office letterhead. that's using your office for a strictly personal thing, it has nothing to do with the town, and that's not what they want you to be using your town letterhead for. You know, send it on your own stationery. And again, don't use your office to try to really influence somebody to, give this person a job. I know I kind of raced through, but, the Ethics Commission, it's in Boston, they have an enforcement division, they have a kind of a, not marketing, but just sort of, they go around giving seminars like this. And then they have a legal division, and they're the ones who, when your town council sends a formal letter saying whether they think you can or can't do something, it gets copied to the legal division, and they'll say whether they agree or not. They also have attorneys of the day. So if you're concerned that you might be about to make a mistake under the conflict law and you want to check it out first, you can certainly, you go to your town council through the administrator's office, or you can call up the attorney of the day. They're really pretty good about getting back to you the same afternoon, and you can have a conversation about, these are the facts, this is what I'd like to do, am I gonna violate any section if I do it? And they'll give you at least, some good immediate advice. And of course it's free, so I would definitely encourage you. Their website too, I think, is really good. They have a lot of advisories for different boards, they have advisories in different areas, different sections of the law. There's a lot in there, and it can be pretty useful. And that is it. So unless anybody has any questions, either right now or I'll be here for a few minutes. Sorry to jam so much stuff out of you with Lauren and I tonight, but hopefully you got something out of it, and I appreciate it.
Thank you, Brian. Thank you, everybody, for coming tonight, and if you have any questions about the presentations, open meeting law, or conflict of interest, feel free to call me, call Mike Gillette. Thank you very much for your service, appreciate it. Yep. Yes, please, yes. Yes, if you could all leave the first page of the appointed committee handbook, just fill that out and leave that, that would be appreciated. Thank you. Yes, I've already sent something out, but I will take a look and see who needs to update theirs. It's every 2 years. Okay, thank you.